Trial by file, I follow the thread. Names in the margin, words never said. Footsteps in silence, dates on the page. Power in the shadows, locked in a cage. If it's buried deep, we dig. If it's dressed up clean, we strip it. If the record bends, we read it straight. No easy answers, no closed case, no stone unturned. We want the truth, no stone unturned. Bring the proof, honesty first, facts on the line. No stone unturned, till justice shines. When the damage lands, we name the cost. Who got protected, who got lost? Civil rights, every voice, every door. No one ignored, no one invisible anymore. Say it plain, don't dress it up. Show the source, then show enough. Let the public see what's real, so every mind can judge and feel. No stone unturned. We want the truth, no stone unturned. Bring the proof, honesty first, facts on the line. No stone unturned, till justice shines. Respect in the telling, care in the frame. Human before headline, every wound named. We don't chase smoke, we follow the trail. Clear eyes, open records, let the facts prevail. No stone unturned. We want the truth, no stone unturned. Bring the proof, honesty first, facts on the line. No stone unturned, till justice shines.
The defense rests, where humans come before headlines.
Blow you a kiss. What's crack-a-lackin', peeps? This comedy circus of a trial is it's not uncommon that my thoughts on that are unanimous, as we shall see. Mr. well-regarded Ian Runkle, some thoughts on the process as well, and I've got to concur. So let's have a look, shall we? Let's see what he's got to say, because he's very, very, very clever man.
Me off, but this pissed me off because, quite frankly, I think the prosecution lied.
Really?
That's my take on it.
Mm-hmm.
And I think the prosecution is pulling some fast ones on this one. I think the prosecution is absolutely fucking around. And
so eloquently stated.
If I was the judge, I would be like, okay, prosecution, you have just said that that's not your argument. Cool. Yep. I am going to hold you to that. You will call no further evidence to establish that argument.
So they start off saying that Lindsay is faking her mental health condition and she faked her suicide attempts as well. And now they're saying that, you know, well, she could have used more successful methods. So which part of overdosing and slitting your wrists and slitting your throats and then jumping out a window is ineffective because all of them have resulted in her permanently incapacitated. So, the fuck?
And I will give a jury instruction to say that this is not an argument that the prosecution is making,
Yep.
and that the jury should not consider it because the prosecution has conceded this point.
Mm-hmm.
Because I do not brook shenanigans from anybody, and this is some serious fucking shenaniganery.
Shenaniganery.
So let's dive into the shenanigans. Oh, and I'm gonna have to share the screen because of course I do. Also, there's a whole bunch of stuff I'm behind on covering. I know I'm behind on it, and so yeah. All right, but here's what so I'm going to do videos. I'm going to do lives as I can. But let's have a look at what the prosecution pulls this time. And we're just going to go to when there's actually
Return
people.
back to the matter, Commonwealth versus Lindsay, Clancy. All parties are present, excluding the jury.
All right. Well, what I wanted to do was,
So that's important. There's no jury right now. Jury
Right.
is out of the room, so now they can fight.
This is the
And
most.
hopefully you guys can hear it. And yeah, I've got
I believe this is the motion from the defense to allow their expert witnesses.
the other thing I got to do is Red Bull has this summer edition, and Red Bull is not paying me for this, by the way, but they have this summer edition,
That's
and
quite
it's
nice,
this
actually.
lime flavor, and it's really good. So I need to try it. Runkle, have you started your new job yet? No. Last day at the old job is the 13th. First day at the new job is the 24th. So that'll be exciting. All right, here we go.
hear the arguments in regards to the defendant's motion for permission to call witnesses. I know that this was filed this morning, but it's kind of hand in glove with issues that were raised a couple of weeks ago. Same, at least mention the same witnesses. So I'm going to hear first from the defendant. They'll hear from the Commonwealth. I will probably take it under advisement and review some of the other documents.
Take it under advisement just means that the judge is going to be like, well, I'm not making any decisions right now because, yeah, like this is going to be complicated. We need to make decisions later. I probably need to do written decisions. This judge also just had one of his decisions overturned. And so the judge is going to be a little bit careful about things right now. But yeah.
Documents, but I want to make this decision as soon as I can, so everybody kind of can plan on how they go based on the decision. So, so Mr. Reddington, let me hear you first on this.
Thank you. Your Honor, obviously, I don't have to belabor the obvious. This is a murder trial, very serious business, and we've all been working very hard on the discovery, which, as you can tell, is voluminous.
Can I just say, I really like his delivery, and he is smooth about things. I don't know. I wish I was as like smooth with all of this as this guy is, because he's just like, Your Honor, I'm not going to belabor the obvious. This is a murder
I agree. He is a wicked judge.
trial. This is very serious business. And he delivers it just so, like, he doesn't come off at all whiny. He just comes off able to copy it.
They have people going out and interviewing. They have videos. They have chemists. They have detectives. They have local cops. They want a cup of coffee. They can send 5 cops down the street to get one. I'm it, except for my son, Patrick, who helps me out getting coffee. All right. And the reason I sound frustrated is that they are objecting 2 weeks ago because
So what he's pointing out is that there is never an even division of assets. And like the government always has tremendously more assets than the defense. Always, right? If you look at the Tate trial, which is going to be happening, you know, Tate has a whole bunch of money. Like lots of money, and he's a piece of shit, but he's got lots of money. And the assets that the government can bring to it are way greater than he can. Like just absolutely. By the way, if you're wondering why there's like all the like suits up there,
No,
it's because my
And not by way of excuse, but, you know, I am a sole practitioner. In the past, May, June, July, in the past 3 months, I've had a murder, a rape, and 2 back-to-back federal trials that ended.
He's talking about like what he's been doing as a lawyer. Somebody was like, did he just admit? People are
1 week before we impaneled on this case. I have worked really hard to pull this case together with expert witnesses, civilian witnesses, private investigators been investigating. I provide everything to them as soon as I get it, and they have been doing the same with me. I haven't objected to one thing that they have offered. They put an AutoCAD computer animated display disc on my desk last week. I didn't complain about it, run to you and try to exclude it. I said, fine, no problem, put it in my pile and move on.
This is one of the things that I really, really like. He's like, look, I've been super chill. They've been pulling all sorts of shit, and I have been letting them do whatever, and they are not extending the same courtesies. And judges do actually consider that. Judges, if you are holding the other side to like every particularity, then they can do the same to you, and you're likely to have to live with it. But here he's like, look, I've been super reasonable. How come they are not giving me the same benefit?
Because they're assholes.
And I mean, I don't think it's improper.
That's it. So to suggest that they need time to be able to cross-examine both, I've had trials with both of these prosecutors. They're both experienced. They're very, very familiar with the trial of major criminal cases. I feel that they're more than capable of being able to cross-examine, for example, number one, Dr. Volkovich, who is a board-certified emergency medicine physician. His report indicates that he has taken a look at South Shore Hospital. He's taken a look at the Brigham and Women's Hospital. He's taken a look at the photographs. That's their evidence. That's all he looked at. And all he's doing is basically what all of their South Shore doctors came in and testified to as to the nature of the injuries, in his opinion, the type of injury that she suffered, talking about the injuries to the right and left wrist as well as the neck. In his opinion, dealing with suicide attempts, that it's a legitimate suicide attempt. There's no secrets. There's nothing new that they have to prepare to cross-examine him on. Dr. Lapasada is a doctor that is well known to most of us, and I've been using.
Dr. Lapasada is a doctor that is absolutely known to all of us here. Dr. Lapasada is like, we are fans of Dr. Lapasada here, and she like the last trial that we saw her in was just absolutely, she was a meat grinder. Like Brennan took a run at her and she just curb stomped him. Like she just rolled him up into a ball, and so yeah.
Dr. Lapasada's fine services for the past decade or longer. I know that both of these attorneys are familiar with her. She's not bringing anything new to the table. She's bringing her opinion based upon their evidence as to the medical records, x-rays, all of the rest of the indicia of the injury that she suffered. Now they're talking about.
And I'm just going to say, if I was the prosecution on this, I would probably say, look, like the defense case isn't happening tomorrow. It's not happening the day after tomorrow. So those witnesses are a little ways out. I don't think it's going to be that hard for, for the prosecution, the Commonwealth here, to get ready to cross-examine these witnesses. I really don't. So this should be something they should be ready to do in a couple of days.
Lindsay going out, hanging off of a window, and then doing, like I said, the Spider-Man slide down the side of the house, apparently. Absolutely ridiculous. She dove out that window, she hit her head, and she suffered what Dr. Lapasada refers to as a Jefferson fracture of the spine that is very, very, very typical for this type of an injury. When somebody dives into the shallow end of a pool, they get that injury, unfortunately. When somebody, kids are on a boat and they're drunk and one of them jumps off a mast into the shallow end of the water off of Cape Cod, they get that type of injury.
He's like, she Supermaned her ass out the window and flew straight into dirt. It's like the prosecution's theory that she was hanging down off the thing doesn't make sense for her to get the classic injury that you get when you crash into something head first. So, like, I don't understand the prosecution's theory. If, like, the prosecution doesn't seem to be disputing that she has that injury, are we going to get more witnesses? I see people in the chat saying, what about if the ground was frozen? Fair. Yeah.
Superman, when you get thrown off the horse, 6 feet high, same injury. That's all. She's not bringing any esoteric theory to this case that they need time to prepare. Interestingly enough, the Brigham and Women's Hospital records do make reference to the Jefferson fracture right from jump. She also assists me, as she always does, on autopsy photographs, any indicia of injuries, and it's her opinion that if they try to say that there are bruises to these little babies that were inflicted by her, they're absolutely wrong. And Dr. Lapasada would indicate that these are consistent with either EMT, God bless those first responders, but they were in a panic and they're trying to take care of these kids and pick them up and run them up to their trucks and vehicles. So
if you get seriously injured, the EMTs are probably also going to seriously injure you. And what I mean by that is they're going to cause you bruises. They're going to cause you bumps. And if you're really seriously injured, they may cause you like broken ribs. They may cause you like all of these things. The EMTs don't care about whether or not you get bruises. The EMTs don't actually, are upset by this.
Bruises from medical intervention, not Lindsay Clancy. That's what she would testify to. That's it. They don't need time to prepare to cross-examine for that. Finally, I have Dr. Condi. Dr. Condi signed even better than a report. He signed an affidavit. And again, it's based upon medical records that we all have. Way back when this case first started, the government presented the case to the grand jury. First thing I said to Lindsay was sign a release. Let the government get all the medical records. We'll all have access to them. This case is obviously going to be predicated upon the medical records, psychiatric records. We signed every release. They got every document and had them into the grand jury. I got copies. They have copies. Condi would testify to the horrific, in his opinion, failure to comply with the standard of care that would govern psychiatrists, psychologists, Dr. Tufts, who's going to be testifying tomorrow, nurse practitioner Gelada, the other individual from the McLean Hospital, all records that they've had for years.
Yep.
So they don't need time to prepare for cross-examination. So weeks
kind
ago,
of belaboring the
counsel,
point at this
after
point.
I gave them copies of all of these reports and affidavit, strike that, I'm sorry, the reports I just got, and I just sent them the affidavit from Condi they already have. I disclosed to them what my opinion would be of the opinions from these doctors that would be testifying, and the report carries that out. I suggest to the court that to strip Lindsay's ability to present evidence in support of her defense, number one, it would not be in the interest of justice. How?
So they're talking about late disclosure here, and quite frankly, I think one of the things that needs to be considered is that she is the defendant, right? And because she's the defendant, she's always kind of on the back foot.
Mm-hmm.
But I get the prosecution's argument, but I think that the argument, or the counter argument of, look, this is nothing new. This is nothing exciting. This is nothing.
This all they're asking for is for their experts to have opinions on the exact same evidence that they've both had for years. That's it. And I must say, I'm a bit excited to see Dr. Lapasada again, just quietly.
You know, I had a case at one point where I wanted to file it, or I filed a charter notice, and it was a day for a very
Come on,
Canada.
I do love you.
Rather than hangout thing. Go.
I'd like to hear a DA stand up and say, in the interest of justice in this case, because weeks ago we got this information and we're not prepared to testify, to cross-examine the testifying witnesses, I think even Your Honor would agree is a disingenuous argument. She came in and said to you, well, Rule 14 matters, and it applies to the government just as it applies to the defense. And therefore, you should exclude these witnesses. Well, if I messed up, and it's my trial schedule that caused me to not be able to have written reports of the stuff that they've had for years to prepare to cross-examine these witnesses, then it's my fault. And it deprives her of effective assistance of counsel, because that would then deprive her of her defense. This is a pathologist, an emergency room doctor, and a doctor who would testify to the standards that would apply to these doctors that they're going to call as their witnesses, which is another interesting fill-up, if you will, where they're calling Tufts, Gelada, the other individuals from McLean, all treating physicians of her that are all lined up to come in and
Oh, and those treating physicians. Oh, man. We're going to have some thoughts, folks. We're going to have some thoughts. We're going to have some feelings.
testify against her on this case. Fine, bring it. But at least give me the ammunition to counter it.
Let me ask you this. I kind of go backwards.
I like his strategy. He's like, look, I'm letting them do whatever they want to argue this, but you got to let me fight back. It's a good argument. And hey, Nick Starro, good to see you. Thank you for the 5 gifted memberships. I thought I should call that one up while you're here. So, and I happened to see it. So, yep.
In regards to Dr. Condi, the affidavit really speaks more towards the standard of care.
That's right. He's not giving an opinion of criminal responsibility.
Right, but I'm struggling to see how that comes in. Now, maybe.
Well, he's the doctor that I'm using for toxicology.
That's what I feel. But the reason I'm asking that is, I'm not sure. In this case, is this the standard of care necessarily as relevant as opposed to causation? Do you know what I mean?
Well, yeah, I think the standard of care does speak to causation. Doesn't have to use.
The standard of care kind of obviously goes to causation, because if they fucked up the standard of care,
then that's going to cause the.
Like, we're talking about medical treatment here, right? And so if the standard of care, for instance, is don't kick the person in the balls, then that would go to causation of why the person has sore balls.
Yeah.
Right? Like,
do that.
You know, hey, we gave them the wrong drug
100%.
for their cancer treatment, and the cancer killed them.
Yeah.
It's like that obviously goes to causation as to whether, so yeah, obviously this makes sense to me.
Use it as standard of care. He can use it as his opinion as to the first doctor that she spoke to, Dr. Tufts, when she presents with a bipolar 1 presentation, and then Tufts prescribes an SSRI to her, which flies in the face of any rational psychiatrist and what they would prescribe and do. He's more than qualified to testify.
That's a different question, and that may be more admissible than someone saying, oh, I found what the standard of care, and I find that this violates it. If we have got an expert who says, listen, I am qualified, I looked at these records.
Okay, so are you going to say that we're going to exclude all evidence as to like whether she properly took her meds? Because if so, that would be fair. That would be even. Oh, wait, no, you didn't do that. You've been allowing that in. You've been allowing in everything to say that she hasn't properly followed whatever, but now you're not going to allow in the evidence as to why they didn't follow it. Huh? I got some thoughts about that.
I disagree with that treatment. I'd be more inclined to allow that than to get into the standard of care, which is obviously consistent more with the civil world.
So with that, I can reach out to Dr. Conde and have him delete reference to standard of care in his report and address the actual treatment as to an opinion as to its appropriateness. But again, on the issue that they're raising, that they need time to prepare to cross-examine, I don't think that lies even if he revises his report by removing standard of care.
Well, let me ask you this, because I haven't had an opportunity. This is probably what I'm going to have to look at tonight. Is Dr. Conde adding anything to the expert disclosures that have already been made? Because I know there's disclosures.
He's taking the medical records, Tufts, Gelada, McLean Hospital, and just commenting on the care and the treatment that was presented to her as a patient looking for.
I mean, it is super relevant that people should not get SSRIs if they are bipolar, because SSRIs are extremely bad for bipolar people if you're not very, very careful, which they didn't seem to be. Like, we did hear testimony that, like, oh, you can give an SSRI to a bipolar person so long as it's also with other stuff to, like, mediate it. It's like, well, did she get any of that other stuff? Fuck no.
The problem is, though, she has not got a diagnosis of bipolar. So,
why would we do that? And, like, oh, my God. Les Etoiles, I just saw that. Les Etoiles says, I just finished my internship at a county district court. Thanks for inspiring me to go into law, Runkle. Hopefully you still feel that way in 5 years, but yeah.
For help. That's all he's doing. He's not adding anything. He's talking about the prescriptions that were provided to her, the SSRIs, the antipsychotics, the benzodiazepines, all of that. That's what his opinion is predicated upon, which is all of the prescriptions that the government has already introduced into evidence and is well aware of.
Right. And so, but I know that the parties have already exchanged reports months ago, and I know that everybody did that. I haven't had a chance to review specifically the defendant's reports. And I don't, is there an expert who's going to address these kind of issues already?
No. Dr. Conde was my toxicologist and my physician that would give an opinion as to the appropriateness of the treatment that she received, especially as it relates to the prescriptions. I mean, Dr. Lapasada is a pathologist. She has nothing to do with it. Dr. Zeisel is a psychologist. He has nothing to do with it. Dr. Resnick is a psychiatrist specializing in infanticide. He's not addressing that issue, and nor is Dr. Spinelli, who is a postpartum depression, postpartum psychosis expert. So Dr. Condi is my expert for toxicology and level of care that she received.
All right.
Which guts the defense if their argument that they need time to cross-examine or prepare.
And Judge, you just got overturned on another case that you argued because you didn't allow in the psych evidence.
Oh.
Maybe you want to think real hard about whether you want to let in the defense evidence, because the Court of Appeal already told you, and
never mind, it's the right thing to do.
Yo, get with the program on that. It's like, do you want to get overturned again? Cool.
Results in an exclusion.
Okay, come on.
Thank you, Your Honor.
And this is where the Commonwealth is going to, in my opinion, bullshit. And oh wait, we need. There we go.
Aw,
Hey, how you doing?
aw.
Oh, it's going well. It's been a hot minute.
Yeah.
Been a bit.
Let's do this. Also, I got new toys I got to show you.
Oh no! What'd you get?
So I got this. This is from the Hacksmith. They have a YouTube channel, but they made a knife, and everybody was asking me, "Is this knife legal in Canada?" Because it does that.
Oh.
It's not legal in Canada.
It is totally legal in Canada, believe it or not.
Oh my God.
But I got to do a video explaining why. This is awesome.
Yeah, that doesn't suck. I don't hate that. I was actually, so you had mentioned this judge getting overturned. I was actually reading. I had pulled up the opinion, and it wasn't that he got overturned on that particular issue. You there?
Yes, apparently YouTube is doing some stupid stuff though. Oh, looks like it's back. Or at least when I refresh, it's back. So hopefully, there we go. YouTube was doing some dumb stuff. This trial is crazy, isn't it?
It has definitely been interesting to watch. You come in there and you're looking at whether or not someone has legitimate defense of not guilty by reason of mental illness or insanity or whatever you call it in whatever jurisdiction you are. And those cases are so rare. And all of a sudden, you're like, well, this one might be the one. And then the prosecution puts on their case and call a whole lot of witnesses that they really shouldn't have called.
I really didn't understand why the prosecution is there. Like, look at all these witnesses who are talking about how great of a mom she is.
Mm-hmm.
Oh, it's going to be even more interesting because I think there's a really big problem with the prosecution's case beyond what has been explained so far.
Mm-hmm.
The experts are all backloaded. So at some point in time, the prosecution is going to put on an expert that says she was not under any mental incapacity when she killed her kids, right?
Yeah.
The expert's going to say that. And if the expert says that at the beginning of the trial, the jury has no other information other than this learned expert who is on the stand, who's testifying and giving them information, right? The opinion is there. After the jury has heard all of these witnesses testify to how wonderful of a mother she was and how that she was struggling. Oh God, the prosecutor asked the one question, I think it was yesterday. I shook my head and stared at my computer and I was going, you did not just ask that question. And it was, did she ever, God, what was it? Did she ever tell you that she wished to commit suicide? And it was to the friends.
Yeah.
And any person who's ever had anyone in their life who's committed suicide.
Hello. If anyone, just before I haven't watched this, and I love Rob and I love Ian, that's why I'm watching it. But if he's about to say what I think he's going to say, and it's been my opinion as well, or my experience, anyone that has had an experience with someone committing suicide, you don't hear about it until it's too late. Okay? If someone's serious about it, they're going to do it. They're not going to tell you. Generally, if people tell you, it's more like they're using it as a weapon. Like, if you don't do this, I'm going to kill myself. If you don't do that, I'm going to kill myself. And it's more for attention and manipulation purposes, which is really fucking sad. But yeah, let's see what he has to say.
How many of them can say that their friend told them that they were going to do it beforehand?
Righto. See?
Approximately 0.
Mm-hmm.
The other one that astounded me that we have today was they asked somebody, oh, you asked her how she was, and she said she was fine. And it's like,
what's she going to say?
Oh, yeah.
No.
It's really dumb. Really dumb. I can't think of a dumber question to ask.
Yeah.
Just
because
like,
who answers anything other than fine to how you're, how are you doing?
what answer is she supposed to give?
Yeah.
Honestly, I was
thinking about jumping out of the
listening
window.
to the testimony about how she said she was in a dark place. She was sad, but it was all these vagaries, nothing really specific. And I'm going, that's exactly what you would tell your friends.
Correct.
Like, that's exactly what you would tell them. Maybe
That's
there's
how
one
people
person
hint
in your
that
life.
things are real bad without saying, like, hey, I am planning on.
Actually, the other thing I wanted to say whilst you're all here, let me just, okay, so, my opinion, now I've forgotten what I was going to say. I hate my brain. Let's go back. Let's go back. It'll come to me. It'll come.
Unaliving. Like,
Oh, yeah. So the prosecutor put all of those witnesses up and asked all those really dumb questions. So now the jury in their mind is sitting here going, well, I've heard all these people.
Oh, that's it. Okay, so this is obviously it's a horrendous fucking thing that she's done. Don't agree with it. Don't condone it. But I want you to just go to the point of time right before Patrick leaves to go to pick up the meal. And forget anything past that point. Take the emotion out of it. Take everything, your personal biases, especially if you're a grandmother or a mother who's lost children. Yes, it's fucking horrible. But they're painting a picture of a person who has premeditated and deliberately, maliciously done this heinous act out of pure evil, malicious, whatever. And they're saying that there is no connection to mental health or medication issues. It's purely her being evil. Now, answer these questions. 1, has anyone really said anything bad about her? Anything bad about her parenting? Has anyone said, is there any evidence of prior abuse? Is there any CPS involvement? Her friends and everyone that know colleagues say she's a great mum. There is no history of anything. Also, if you were personally invested, you have emotional connection to these children, which a lot of these witnesses have had, they knew them themselves, and particularly the grandfather. Now, I know a lot of you out there have grandchildren, and there is not a fucking court in this planet that would stop you from speaking your mind if you believed that there was justice that needed to be served. Now, think back to the grandfather's testimony and the ex-husband's testimony. There was their perfect opportunity to throw as far under that fucking bus as they could. Okay? They have every right to be absolutely furious with her and despise her. And yet none of them said anything bad. So they're the ones with the ability to shout it from the rooftop right there to get that justice, if they truly believed that justice was required. Okay? That's what I think anyway. Let's see what the boys go.
Cool. And now I believe that this person was in mental crisis and didn't really have anyone that was listening or didn't have an outlet.
Mm-hmm.
And then the prosecutor is going to put on the expert that says, no, she wasn't.
Yep.
At that point in time, the jury has 90% made up their mind. They're either she's in mental crisis or she's not. And if they're in the camp of she's having a mental crisis or she's not capable of forming that intention at that point in time, it doesn't matter what the expert says. They will disregard that expert like it was yesterday. Like they don't care. So I think it's just really dumb. You don't have to call these witnesses and then to put them on the stand and cross-examine them.
And the fact is, like, no one has disputed the fact that the children, A, are dead, and B, that Lindsay did it. So why put on all of the evidence showing that? Why put on the autopsies? She's not ever denied criminal culpability. There is no need for it. None. That the defense stipulated to all of it. It's not a who, it's not a when, it's not a where, or how even. It's a fucking why. Why? Why did this happen? That's it. Prosecution saying it's because she was a cunt, and the defense is saying it's because she was trained. She didn't get the help that she needed. And truly, can you list anything else? Anywhere else she could have looked for help? Anywhere? Did she do? Oh, sorry. That's really bad pause, Rob. Sorry. She went to her GP. She got referrals. She saw umpteen psychiatrists, therapists. She presented at fucking emergency departments. She even went to an inpatient fucking locked psych rehab. What more could this woman have possibly fucking done to help herself? Truly.
I mean, I just don't know what their goal is sometimes.
Yep.
So, yeah, this is also kind of a cultural thing because I know there's some people in, like, you know, there's some people who are watching who are probably from like Scandinavia. And Scandinavia is a place where you have to stop asking, how are you doing? Because how are you doing is an incredibly rude question there.
Oh, all right. Let's move on.
Because they'll probably answer you, but sort of a different, they're going to, you know, here they probably wouldn't one goes. But like through North America, I'm good or whatever, fine. Right? Like,
yeah. Yeah. I go straight into the profanity, but like, what's.
Or,
let's go.
You know, for seeming normal, appearing normal. You know, it's people who are in psychosis aren't necessarily like obviously floridly whatever. There's various forms of psychosis where people can seem outwardly normal and okay and whatever and be completely not. Paranoid schizophrenics, for instance, are very common on that.
Here's your Scandinavian, Niklas. We're not rude. We just lie because we don't want to bother anyone with our problems.
Yep. Yeah. Yeah, and this is Hunk Banana Nose got a good point here. Where did that scroll to? There we go. In the U.S., how are you doing is meaningless. Any answer other than fine or good, thanks, is incredibly rude. Yeah, it is considered rude if somebody asks, how are you doing? And you're like, well, I kind of got diarrhea right now. Like, I didn't actually want to know, right? Like, you know, or if you answer like, I'm really sad, it's like, I didn't.
Those of you that haven't met these guys before, so Ian Runkle is Runkle of the Bailey and his huge law tuber. And Rob was one of the very first YouTube creators that I watched way, way back. And he's from Law and Lumber, and he had a massive following YouTube channel. And he recently stopped streaming because he'd moved house. He'd started his own practice in law. They're both lawyers. Ian Runkle is a criminal defense attorney with a specialist in guns. And Rob is a family court, family law. So he started up his own practice and has been extremely busy and was getting married and had the instant family. And yeah, he sadly stopped his Friday night frenzy streaming, which is a bugger. And these two have been long-term friends. So they're really fun to watch. So have a squiz and have a listen. They've got a lot of legal based opinions that they like to share, which I find really interesting.
Didn't actually care that please don't.
Well,
Plus, Rob's pretty fucking hot.
Use that question.
It's kind of funny because I meet with clients all the time to prep them for trial and to go through their stuff. So I have the client come in, and the first thing I ask them is, "What do you think it is? How's it going?
How are you doing?"
And then sometimes I'll actually catch myself and I'll say, "That was rhetorical. I apologize. Like, you're probably in a really shitty place right now, but let's go ahead and chat."
I actually had to remove that one from my repertoire when I talk to people who are in custody, because it's like, how are you doing? They're like, well, I'm in jail, fucko. Yeah. And it's like, right. So instead I would, just begin with something like, I'd ask how you're doing, but you're calling me, so probably not very well. Let's see what we can do about that. And that way you get less arguments and so forth. But how are you doing when somebody's like, I'm in jail. And
how are you doing?
Oh, wait, I got to fix the audio because I switched the audio. It over. Yeah. Okay, hopefully this will work.
One of my points is going to be that his affidavit addresses the standard of care, which is more of the civil issue, but you've already addressed that with defense counsel's pivot, that he would then instead testify about the treatment of the defendant in toxicology. Looking at the affidavit in which he outlines his qualifications, he's not a toxicologist. He's a physician licensed here in Massachusetts. He's done a residency in general psychiatry, child and adolescent psychiatry, and forensic psychiatry, but he's not a toxicologist. And also, it's not just us having all the same records that makes for cross-examination to be fundamentally fair. There's more to cross-examination than just having the underlying data. It's also knowing more about the expert, being able to look into their publications and their prior testimony, and being able to prepare to rebut anything that they might testify to.
Take a weekend.
Like, it's not that hard. Like the scope of the testimony here is not something like this expert could take the stand, and any attorney that's been familiar with this case should be able to cross-examine that expert pretty fucking easily.
I mean, you are the state. If you need to, pull a few pull a few lawyers and just say, hey, your weekend task is get off your butts and do this. Like, not hard, guys. This also, it's Dr. Lapasada. So just call up Hank Brennan and say, hey, what are the weaknesses with Dr. Lapasada? And then just listen to 45 minutes of him screaming incoherently into the phone. And then you're like, cool, got it. That'll be my cross-examination strategy. It's just cosmic terror. She was in the Karen Reed trial, and Hank Brennan took a run at her, and it did not go well.
I remember, and he got shut down because her credentials were pretty astounding. Oh my gosh, StreamYard lets you pop out chat now? No way.
What? It does. I am. Oh, hey, there's there's a pop-out. Oh, cool. StreamYard is making all sorts of improvements. So, yep.
And where we have this late disclosure, which was 1 week prior to trial starting, that's fundamentally unfair to the Commonwealth. And I think what Dr. Condi would be testifying to, if it's just limited to her treatment and what was prescribed to her, that's covered by the other three experts that defense already has. They all talk about her treatment, the prescription she was on, and the effects those had on her. So I think that would be redundant, and it would be unfair to the Commonwealth to add this fourth expert to talk about the same things that the other three experts are going to talk about when we haven't had a chance to prepare for this particular expert. For Dr. Lapasada, what we have is a 2.5-page letter to Attorney Reddington outlining her thoughts, but it doesn't say what her opinions are based on. It doesn't say which materials she's reviewed and what she's relying on. So I would suggest that it's an insufficient report. And again, with the delayed disclosure, for example, she talks about Jefferson fracture causing the injuries. Well, if we had this information previously and knew this is what they were going to argue, we could have obtained our own expert to talk about the mechanism of injury and Jefferson fractures and all of those things. But we weren't.
Isn't that didn't he just finish saying that this is in her medical report?
Yeah, he did.
You already. So, okay.
Weren't told until a week before trial that she would even potentially be a witness. And then we get this report on July 26th. That's a 2.5-page letter.
But didn't we have multiple trauma surgeons, neurosurgeons who've testified, who treated her? Couldn't someone just ask, is that consistent with, and that's pretty much, if I'm looking at Dr. Lapasada's no. I'm not sure I would allow in opinions regarding whether or not it's a serious suicide or not, but she does indicate it's consistent with landing on somebody, on an individual's head.
Well, Your Honor, we had a trauma surgeon from the South Shore Hospital testify who said that the injuries that Ms. Clancy sustained were a level 1 and she had to be transported to another hospital where doctors who were trained in those injuries could.
He's like, you called every medical professional who's even heard of this case.
That's my problem. That's my big problem. Why did the Commonwealth make it this big of an issue? Like, is there really a question that she sustained injuries? Physical injuries? Like, is that?
Well, she's trying to play fast and loose both ways, but I mean, they practically called are you a surgeon at this hospital? Yes, I am. And what was going on when, Lindsay Clancy came in? Well, I was in the toilet and I didn't see anything. Okay. They called every freaking human who was anywhere near this. I like the judge's expression of exasperation on this. But I mean, the problem is she's been hinting that it was not a real attempt and that this is just something she did in order to try to cover for it. And then she's going to back away from that in the least honest way. It's just, it feels so greasy.
Operate on her. So we didn't think that she would have the knowledge and the training and experience to testify about the nature of those injuries and how they occur. The trauma surgeon from Brigham and Women's Hospital is with the military and is overseas in the Middle East, and so was unavailable. But had we known that this was going to be an issue and they were going to allege this particular type of fracture, we would have endeavored to get another expert in replace of the doctor who treated her at Brigham and Women's. But we didn't know that this would even be an issue until a week before trial. And again, this letter is dated July 26th, and it doesn't tell us which records, which reports, or which, what medical journals or training or anything that these opinions are based on.
Well, that could be done by voir dire. I mean, the Commonwealth has at least inferred through their case that this was not a serious suicide attempt.
they haven't just inferred it. They've been fucking skywriting it.
Yeah.
Like
these scratches or these cuts are superficial. How many times did we hear superficial?
Yeah, superficial, and there was cross-examination over this. Like everybody knew where that was going.
And let me ask you this: why did we give a shit about the blood on the window and the blood on the side of the house? Why did we give a crap about any of that? Why did we care? Why did that have anything to do with whether or not she either A, committed the murders, or B, had the mental acuity to do so?
Yeah. I mean, what they're trying to suggest is that she wasn't jumping like Superman style. She was climbing down so as to minimize her injuries. But I mean, she hits her head. And so what are they thinking? That she like lowers herself down and then does like a diving backflip? Like, I mean, I guess she is pretty athletic, but that's some
I was laughing at the world. The World Wonders super chat. Why does every single judge get infer/imply wrong? You're correct. It was the Commonwealth cannot infer something. They can imply something, and someone can infer from that implication. But everyone gets that wrong.
Yeah.
But yes, the Commonwealth has been implying, and everyone has been drawing the inference from that implication that is, yeah, that's what their theory is, that this was somehow a faked suicide attempt. Or that she didn't mean it.
And then she's going to try to pretend that's not what she's doing. And, I have some thoughts about that. And here she goes.
Right? I mean, and there's questions about whether or not somebody's hanging outside the window or not. And so why wasn't this an issue that the Commonwealth could have anticipated would come up?
How could you not anticipate your own fucking argument? Like, I feel like that should have been anticipated.
Just a bit.
Like, how could you not anticipate your own position?
And this is why I like
to try to say now, not her position.
The position of the Commonwealth isn't that it wasn't a serious suicide attempt. It's
really? Which one? Which one? The pills or the knife cutting or the accidental climbing out a window?
That the methods that were chosen were insufficient to achieve.
Methods which the chosen were insufficient. She chose the wrong way to do it. Yeah? She should have done hurry-curry as she was jumping out the window with a noose tied to the bedpost.
Achieve the goal.
Wait, pause there. Tell me the difference between the two things that she just said. Like really hard. Just tell me what's the difference between those two things.
The Commonwealth's position is not that this is red, but instead that it is crimson.
It's like a shit job of it.
What? Yeah, no. Like you would have stuck better with the yes, Judge. That was what we were trying to imply.
Like the methods chosen were insufficient to achieve the goal. The thing you want is for the jury to conclude that she was not actually making a serious attempt. That is
Judge,
literally your entire point.
Yeah, Judge, we were proving everything we needed to right up until the point when the jury could make the improper inference. Like we were proving all of it and just leaving that little window for them to make an improper inference that we know we can't actually say.
Yeah. And that's exactly what she's going to do. She's going to say, well, I've just asked every witness about whether these were superficial. I'm going to say that the methods chosen were insufficient to the goal. And I'm not going to say that it wasn't serious, but I'm going to ask the jury to make that conclusion. I'm going to hint.
Yep.
And so if I was the judge, I'd say, okay.
And that's when I say the prosecution's been dodgy as fuck, but I can't put it into words. These guys can tell you the legal terminology for them being full of fucking shit and shady as fuck, basically.
Commonwealth, I want you to confirm that you are not making that suggestion to the jury. I am not going to make that suggestion. Okay, then Commonwealth, I am not going to permit any further evidence to suggest that, and I'm going to give a jury instruction to the effect that the Commonwealth agrees that this was a real attempt and a genuine attempt. Is that acceptable, Commonwealth, or are you full of shit? And did you just lie to my fucking face? Because that's what I conclude from this. Like,
Yeah.
I mean, you know, if I'm the judge, I'm going, yeah. And I mean,
Oh no, I'm with you. I'm with you.
you look at his facial expression right now. That is the facial expression of somebody who she just shit his pants. It's like, you know, he's like, how stupid do you think I am? And apparently she thinks he's real dumb, right? So, I mean, if I was the judge, I'd be writing an opinion right now that basically goes, listen, I might be real dumb, but I'm not that dumb. Like, you know, I might on occasion have like opened a package and then thrown the food in the garbage and gone to take a bite out of the package. But I'm still not going to buy this shit.
And the reasons for that, we would argue in our closing. I don't think we have to disclose that theory at this point.
The reason for that, which you don't want to disclose,
Because you haven't got one.
is because you're trying to say that she was faking it.
Yep.
Jesus Christ.
But we've never said it wasn't a serious suicide attempt. We've never said it.
But you have been hinting it, and you're planning on saying it.
Mm-hmm.
So, I mean, this is the hard part about being a judge, is that he's not allowed to just pick up that water bottle off his desk and just eat it. Because I'd be just wanting to just bean her with it and be like, nope. Try again.
It was a fake suicide attempt. What we've endeavored to develop from the testimony is that the methods that were chosen were methods that would be unsuccessful, but we're not saying it wasn't a serious attempt. And I think the reasons for that will become clearer when the doctors give their testimony. But it's our position that she was attempting to kill herself that night, and there are various reasons and factors where she was unsuccessful in killing herself, but successful in killing her children.
But
the judge's expression is just like, that was a lot of words.
Yeah.
And I'm sure those made sense in your head, but we live in the real world. And what the fuck? You know what the sad thing is? The sad thing is that they have a very good chance of getting a conviction at the end of this.
Well, the sad thing is we haven't heard any of the evidence that we need to.
Yeah.
Like, I want to hear from the experts that have actually done the evaluations, that have met with her post-trial, who have an opinion to offer as to whether she is or afflicted with any of these conditions, and whether she at that point in time when this took place would have been impaired by that.
Yeah.
I haven't heard shit about that.
Thank you.
Yeah. I mean, I'm
We
sure
started to today.
Experts. Well, I mean, most of their experts today were just talking about how fucking awful the treatment she got at the time was. And they thought they were doing well. That's the sad part. The experts they got today just the experts they got today really kind of are a testament to what psych treatment is like.
Yep.
And just how
Yes.
it'll
In
help. with somebody who's actually in distress.
Yep.
And this is something I was going to talk about too when we get there, but let's get through the motion argument, because I do want to get to that expert, because I want to talk about all that she's testifying to. It drove me nuts.
Which one? The first one, or like
First.
Doogie Howser?
First.
Yeah.
It was the first one that was at the county run facility, or the McLean Institute.
Yeah, that one just made me rage. But okay. Well,
There's been all kinds of testimony regarding, it seems to be a dispute of whether or not she's hanging from the windowsill or goes out head first. There's some testimony that's been raised, even with the blood experts, things that she may have been hanging from the windowsill. Dr. Lapasada, it seems what they're seeking here is those injuries are consistent with somebody who lands on their head.
So would the court allow us to call a witness who's not on our witness list to rebut that evidence?
Yeah, I would consider that. Sure.
I would have no problem with that.
And this is kind of what
I love.
Well, hang on. So this is the point where they call in Hank Brennan?
I mean, there's times when this defense lawyer has been pissing me off. And the thing that pisses me off is when he fails to object when she starts testifying. When the prosecutor is like,
Oh, she's leading all over the place.
yeah. And I'm just like, I mean, and I can't say that I'm right, because Reddington is real good.
Yeah.
And Reddington is real experienced. And, I can't pretend I'm as good as Reddington, and I can't pretend I've got as many years as he does. But, I mean, I'd have been trying to spank that prosecutor to be like, no, you can't lead your witnesses. Because she just, straight up testifies for them at times.
Yeah. Isn't it true that you don't get to do that? That's your witness.
Yep. And she'll talk for 6 minutes, and then she'll be like, correct? And her witness is like, yes. It's like, no, that's not out. You're literally just testifying for your own witness. Oh, it's maddening. And that is my one big criticism of Reddington.
I have a theory on that. I think that he's just given her enough rope, because in the end she'll hang herself.
I think it's intentional, because her questions are so scripted. They're the same question for everyone.
Yep.
The thing is, though, I don't know. Sometimes you just make them do it to get them off their game, but I don't know.
I know. I disagree with the strategy, but I think it's a strategy. I think it's his strategy.
Yeah, and I mean, you can see the other half of it where he's like, look, Your Honor, I'm so amenable. When she says, can I call some witness who's not on my witness list? He's like, I'm just fine with that. You're good. Call whoever you want. Call a series of surprise witnesses, each more surprising than the last. I mean, who's she going to call? Like Bozo the Clown?
Ghostbusters. She's going to call the Ghostbusters.
So, I mean, I still like the judge's stank face and all of this, but okay, here she goes again.
Why I didn't make a decision on this earlier, because I had to kind of see how the case develops. And this issue of how this injury occurs is certainly, it's either been specifically and explicitly raised or inferred in multiple questions.
Implied. And yes,
Implied.
She's been specifically raising it. Just absolutely, it's so obvious the argument she's making. And now she's trying to pretend she's not.
You know what? It wouldn't be as obvious if Reddington didn't hammer in on it on cross-examination with every single witness. Like Reddington comes back and highlights it even more. That how serious the injury was.
And then she turns around and leads her witness on redirect to be like, yeah. So, it's frustrating.
Even to the length of to the part, the cuts and things like that. It's been over and over and over. So if the Commonwealth seeks to get somebody to rebut that, I would strongly consider that. And in regards to Dr. Lapasada's opinion, we may need a voir dire in regards to, but I wouldn't imagine the voir dire would take that long. It would be, you know, did you view, you know, the x-rays? I mean, that kind of an injury is probably pretty clear on the x-rays or the MRIs.
If we could get a list from defense counsel on what she's basing her opinion on, so we can have our witness review the same material.
I'm just telling you right now, it's just simple. It's just the South Shore Hospital medical records, Brigham and Women's medical records that have already been discussed with the jury.
Why don't we do this, just so it's clear, because when a witness is on the stand, it's much easier to have something in writing to say, is this what you relied on? So if you could get from Dr. Lapasada what she is relying upon to form that opinion, I'm like I said, I'm inclined to allow that opinion, and I would allow then the Commonwealth to present a rebuttal witness if they seek to.
And just note our objection to that, but also the third expert, what we have here is a letter dated August 4th. That's a page and a half. That's not even signed by, I believe it's Dr. Volkovich.
Yeah. I'm more concerned with that is whether or not the opinion is admissible. The opinion, as I see it, is he's reviewed the medical records, and it's his opinion these are injuries that commonly observed in the quote, serious suicide attempts.
We could delete serious.
Yeah, I mean, or even suicide attempts. That's an opinion.
Yeah, doctors waxed eloquently about suicide and whether or not it's, I mean, they delete serious.
But I'm just concerned that how are we going to kind of parse out what he looked at? 100 other cases, and then
And this is the kind of shit that really fucking gets my goat. Like, you know, everyone says, let's have transparency and, you know, it's justice and let's put this in evidence to the jury. But the way they go about allowing evidence in or out sometimes really fucks me off. Like, why can't you say the word suicide when someone attempted to commit suicide? Like, the jury should be able to hear that word. That's exactly what it is. Not just one way, 3 fucking ways. Like, you can't pussyfoot around it because it's a nasty word that the jury don't want to hear. If that's the case, why show the fucking autopsy photos? Why? They're not disputing how they died and who did it. There is no need for any of that shit. But now, oh no, be careful, don't say the S word. Fuck off.
We go through into all of those. So I'm going to have to take a look. That's what I'm going to take under advisement for sure. That doesn't mean he may have other opinions I'm going to have to look at. I think he talked about some of his observations as an emergency room doctor, I think, didn't he? Yeah, I'm more reluctant to allow in that individual's opinion that this was a suicide attempt.
So
I mean, the problem is that you've already allowed in all of the Commonwealth's suggesting that it wasn't a suicide attempt. So now, why aren't you letting the defense argue that it was? You know,
has anyone suggested that these were not self-inflicted wounds?
Well, the Commonwealth has repeatedly gone and said, "Oh, they were self-inflicted," but they're just
that's right. They weren't deep enough to actually have done the job.
Yeah, they're just, you know, ornamental. And I'm like, yeah. I don't know. This ticked me off a lot. All right, carrying on.
Yes, I'm sure doctors are able to talk about, you know, superficial, as we've heard for a week now. But his opinion that it's consistent with what he's observed in his emergency room treatment is not admissible?
No, that's not what I'm saying.
Oh, I'm
What
sorry.
I'm saying is that he can't necessarily give the opinion, I've looked at this, it's my opinion, this was a suicide attempt. But he can certainly testify, I've looked at the cuts. These are, the phrase superficial. I think that's been kind of mixed up in this whole thing too. That seems to be more of a medical term, as opposed to.
Well, no,
that.
they basically beat it to death with it not being a medical term until we were able to show that in fact it was deep, 3.5 and 2. Okay.
Yeah, I mean, if you want to call this doctor, he's going to say, but that's a significant cut.
Okay.
That's different than saying, looking at that, I find that this is a suicide attempt. Just like there's never been an opinion here that this was not a suicide attempt. That's probably something that the jury
now, but it wasn't a week ago.
Well, that's going to probably be for the jury to determine. But I would allow kind of going into the characteristics that have already been testified to. We need a further voir dire on that doctor as well. But I think he listened there, kind of what he reviewed. But yeah. All right. Anything else in regards to those three witnesses? All right. So I'm going to take this under advisement, but just kind of for what I'm inclined to do is I'm going to take a look at Dr. Condi's report and compare it to some of the other reports. I'm inclined to let Dr. Lapasada testify the
Oh my God, everybody is so happy about that. Dr. Lapasada, like everybody is a fan of, except the Commonwealth.
that the injuries are consistent with basically a fall on the head. The last doctor, I'm going to take a look at kind of his language, but I would not be allowing in that his opinion that this is a suicide attempt. But he may testify as to all the other observations that he took from those records. All right.
Understood. Just no objection for what it's worth.
All right. And so I'll note the Commonwealth's objection. I'll note the defendant's objection. And like I said, I'll take it under advisement and everybody can renew those objections
As it
again.
relates to Condi, once you make your decision, you let me know. I can certainly reach out to him and have him delete this standard as to standard of care and just reference the actual treatment and prescriptions that you received.
All right.
So why are all the male judges in MA white? Because they're old. You don't get to become a judge in your 20s. So that's why. Why are not all of the women white-haired? Because they dye their hair. Like that is the reason. So
I'm also convinced that being a judge ages you 10 times faster than being not judge. Having seen judges that have taken the bench and like seeing them like 6 years later. Yeah.
We also had a fair number of judges who have like taken the bench and then died. So it's not super uncommon for judges to not make it too long into the process. So, but yeah, I mean, the other thing is you get like in criminal law, you get judges who are like on the top of their game. They're defending nonstop murders and like national interest files and all of that. And then they become a judge in provincial court, which is sort of the, equivalent of, it's like state court, except that it's only the more minor stuff. Like there's no murders.
Yeah.
And then suddenly you see that they are super, super bored. And like, I feel bad for them because they get into court and they're like, I hate everything. And it's just, so I feel like that's got to age people as well. But yeah. I need to finish this off so that I can start another one. I'm tired of this, but all right. Let's I gotta turn up the volume on the court feed because the court feed is never enough volume. And turn on captions, but here we go.
Yes.
Yeah.
Aaliyah Goodhart.
Yeah. How long did it take you to realize that she is definitely someone being sued?
Not only being sued, but like that maybe the lawsuit is gonna go places.
Well, I think it's
I'm so glad I'm not the
her
only
answers
one.
were so cagey to both of them. Like she didn't want to give a straight answer to either one of them, and I was like, oh God.
But not only that, but like a lot of the things she does answer, the answers are super depressing. Like
Yep.
you're like, oh my God. Oh man. So here she is.
Brace yourself.
Now, one thing we could do to improve the court process is to have walk-up music.
No. Worst idea ever.
Dun, 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 dun. I think that might be her walk-up music.
Watch yourself, please. Right, good morning, Doctor.
Good morning.
Hi. I'm going to ask you when you sit down if you speak loudly so the jury can hear you and speak into that microphone. Okay?
Thank you.
All right, thank you. Counsel.
Thank you. Good morning. Good morning. Could you please tell the jury your first and last name? My
Narrator. She would not have a good morning.
Her morning was decidedly not good.
first name is Alia. Last name is Goodhart.
Can you spell your first name for the record?
ALIA.
And your last name, please.
GOODHEART.
And what do you do for work?
I'm a psychiatrist.
And can you tell us a little bit about your educational background to be a psychiatrist?
I got my medical degree from the State University of New York in Brooklyn, the Health Sciences Center, and I came to Boston to do my 4-year residency at the Harvard Longwood Psychiatry Residency Program. I also trained for an additional 3 years at the Boston Psychoanalytic Institute and got my advanced training I attended the advanced training program, and
Are you licensed here in Massachusetts to practice?
Yeah, that's my line. Stop stealing my line.
Just as a psychiatrist?
I am.
Are you licensed into any other states?
No.
So you said that you're a medical doctor with a specialization in psychiatry, correct?
Correct.
Can you tell us a little bit about your work history in that field?
Oh.
Yes. I've worked in several different settings. When I first started out, I was working at Beth Israel in integrated care, which means essentially that you work with primary care physicians, and if they have patients that they have questions about, they can consult you. And if there's a need, you can continue to manage the patient's psychopharm medications. And if it's simple, they can continue to do it, but you're available for them to consult with and to discuss cases. After that, I went to Emerson Hospital, where I worked on the inpatient psychiatric unit for a total of 9 years. I left for 1 year to be the medical director at another freestanding hospital. After that, I worked at the women's prison in Framingham for 1.5 years. And after that, an outpatient clinic affiliated with Tufts. I had a private practice for 2 years, and then I've been working at McLean for the last 5 years.
Okay. And what is McLean Hospital?
It's a freestanding psychiatric hospital that is part of the Mass General Brigham system.
What kind of services does that facility offer to patients?
They have lots of services, including inpatient, outpatient, substance abuse, trauma focused. There are lots of specializations, eating disorder programs. They have residential programs. They have partial programs. So there's a really broad width of.
And what is your role at McLean?
I work on one of the inpatient psychiatric units.
And tell us a little bit about what an inpatient psychiatric unit is.
Patients who come to our unit are referred to us by the emergency department because it's been determined that they need inpatient level of care. You can come voluntarily or you can be sent involuntarily. And once you arrive, we work with the patient.
I have to speed her up because, oh my God.
Oh yeah, you're going to need to.
That.
They're for a certain period of time, which isn't predetermined. It is flexible. So it depends on what's going on. And when you're on an inpatient unit, it's not just that you're seeing the psychiatrist, you're working as a team. So there are nurses, there are mental health workers, there are social workers. And the way it works at McLean is that every day you have a meeting where people discuss what's contribute. There is documentation of that. And
so you can't just walk in. If I could just stop for you for 1 second. Can you tell us what a Section 12 is?
A Section 12 is basically a doctor or social worker or psychologist states that you are being referred to a hospital for admission because you have a mental health condition.
That's
wrong.
Yeah.
Yes.
That's not right.
Thank
You pose an imminent risk of harm to yourself or others.
Yeah.
Yeah, I was at this point like, what? Because this is not.
You have a condition.
Yeah, I was. God, it's frustrating when they do that sort of thing, and you're like,
Yeah.
12 is required for transportation because in the time between when they leave the hospital and they're supposed to get to you, you want to make sure that something could happen and then they could leave. So you want to make sure that the physician sees them at that end and then somebody sees them at the other end to ensure that something hasn't changed. So it's evaluation.
Okay. And at the emergency department, there is a particular type of evaluation that's done before somebody is sent over to McLean, correct?
Correct.
What, from the Mass General, what is that usually referred to?
It's called the acute psychiatric consultation, APS. No. So the service is acute psychiatric services and it's an evaluation.
Are you already getting the feeling that like, I'm just sitting there going, she is really struggling on some of these questions. It should be basic shit.
Yep.
Like, these should not be the hard questions.
No. This is the foundation.
Why is she having such a hard time here?
Uh-huh.
I think I'm just going to also hold my hand up and like hold fingers up every time she says something leading.
Oh, dude, you do not have enough fingers for that.
No.
You're going to get to toes in like 6 seconds. All right, here we go.
So it's a complete evaluation by either a nurse practitioner or a psychiatrist. And they go over things like, why are you coming now? What is your history? Have you ever had problems before? What's your family history? They document how you're presenting. They inquire about symptoms. And that's how they find out what medications you're on. And then based on that, they decide whether you need, there could be several options. They can recommend inpatient treatment. They can recommend partial hospital program. But the patient doesn't have to do either. If they're not unsafe, they can choose to leave. But most of the time, people take the recommendation and they've presented because they are seeking help.
And unless the patient is deemed unsafe in that involuntary realm, it's their choice.
Correct.
Now, you mentioned that when they come to McLean, that they first come through and have a CEC. What is that?
It's a clinical evaluation center.
What happens at that stage at McLean?
They're seen by a psychiatrist, and there's a nurse as well. They review the history. that was obtained at the emergency department, and they inquire about any. They actually do another evaluation, just like at the APS, basically reviewing all the history, but also asking their own questions. And if they have any concerns, they document them there.
And you said this evaluation is done by a psychiatrist?
Correct.
And when a person comes into McLean, can they come at any hour of the day or night?
Correct.
And when they first make it to the clinical evaluation center, they're always seen by a psychiatrist.
Yes.
And where are all of these admission notes and all these assessments? I haven't seen any. Where the fuck are they? What was her diagnosis? Why?
Now, once they do this evaluation, gather all the information, do they also do kind of a physical exam to make sure that there's no medical issues to address?
Yes.
And after all the information is gathered, what is done at the evaluation center?
So they basically enter the order. May I have some water, please?
Oh, sure. Sorry.
No worries.
My fault.
Can you repeat the question?
Sure. When a patient is evaluated or seen in the clinical evaluation center, what happens after the evaluation's done?
So they determine the level of checks that the patient should be on once they get to the unit, because there are several units. There are at least 4 inpatient units. They decide what medications the patient is going to be able to get, thank you, until they are seen by a psychiatrist on the unit.
And when you say level of check, what does that mean?
Everybody who is on the unit, there's a mental health worker assigned the task of ensuring that all the patients who are supposed to be on the unit are present and that they're safe. And the lowest level is 15-minute checks. If there's concern about somebody, it goes up to 5-minute checks. And if they're extremely unsafe, it goes to a 1-to-1.
And what does 1-to-1 mean?
There would be a staff person with the patient at all times.
And again,
and that is what she was on, which, given that the prosecution's theory appears to be that this was a fake attempt, and I know the prosecution has denied that, but, it's like, okay, so they certainly thought it was serious. Yeah, I don't know. This frustrating.
Yep.
This determination of which unit to be on and what level of security or what level of check is done by the psychiatrist that performs that first evaluation, correct? Now, when a person who comes through the CEC then gets sent to the unit, do they walk to the unit on their own, or how do they get to the unit?
They're escorted to the unit.
And you said there's 4 inpatient psych units, is that
correct?
Now, when the person arrives at the unit, what happens?
They're seen by a nurse and a mental health worker. Their belongings they go through the belongings to ensure that there's nothing unsafe. There's certain things that are not allowed on a psych unit. The nurse reviews their history and takes some vital signs, sees if they need any medication, and then they show them to their room and the unit.
And again, people come through the CEC at all hours of the day and night, correct?
Yes.
So this whole process is pretty seamless and could happen at any point.
Yes.
Stop bleeding.
Now, you mentioned previous.
Yeah, if the witness keeps answering yes on direct, that's not like. I mean, she's not even just leading. She's basically just testifying.
She is.
Like, why is the prosecution just getting away with this shit?
Because, well, it's that he starts objecting, but he doesn't really push the objection too hard. But I don't know. And a lot of this stuff is just also not relevant. It's a ton of background. She's been done with the background for a solid 5 minutes at this point.
Yeah, I mean, the thing is also juries like seeing objections. They want to see the lawyers fight. I am more of a proponent of object to things, especially when you know you can land it, because the defense could be sitting here getting objection sustained, objection sustained, objection sustained, and then suddenly the Commonwealth's witnesses wouldn't know where they're going. Because I mean, I don't know if any of these witnesses were actually prepped. Because she has to feed her own witnesses answers a lot. So, yeah.
That the length of stay or how long a person is on the unit or inpatient varies, right?
Yes.
Is there any sort of minimum that's required when a person comes in for an inpatient stay at McLean?
No.
And if they are voluntarily there, can they leave at any time?
As long as the psychiatrist and the team assesses them and determines that they don't pose an imminent risk to themselves or anybody else.
Now, what if they're there on a Section 12? Is there a time limit or a minimum amount of time they have to be there?
She wasn't there on Section 12. She was on a voluntary.
We haven't gotten there yet. I'm just asking background questions about the facility.
I'll allow some background questions, but let's kind of move it along.
What if she was a pony? Like, why are we asking questions about hypothetical situations that don't apply to her situation? Like, you know, yeah.
So Section 12 entails that that the team and the psychiatrist has 3 days to evaluate the patient to determine whether they pose a danger to themselves or others. And if at the end of that time they do determine that the person poses a risk, then they have to apply for commitment, which would mean going in front of a judge who would decide if the patient should remain hospitalized or be discharged.
And if at the end of the 3 days you deem them to be safe, are they allowed to leave?
Yes.
And is there something in the field of psychiatry or in your training and experience in your time at McLean about being discharged against medical advice?
He wasn't discharged AMA.
I will allow the set.
Why are you allowing to set, like, you know, what? I mean, is the defense going to be allowed to ask questions like, you know, what if the prosecutor killed these babies? Like, if we're able to ask questions about things that obviously didn't happen, like, where does that stop?
Really the terms and where we are, so you can go into that.
AMA is not applicable.
If we can approach,
Yeah, you know, I don't think you heard me.
I did hear you.
All right, well then I'm going to allow that. Yeah, your rights are safe.
My objection.
Yeah, I've noted it.
Judge,
Well,
pull up the fucking diaper, dude.
I mean, Reddington is making some pretty substantial speaking objections. Like this, that's not cool. Like he's openly like telling the jury, this isn't relevant. You shouldn't listen to this.
Yeah, and fair enough too.
Yeah, but still, Judge, pull
I
up your
know.
fucking diaper. Like that. I mean,
The thing is, what happens is the jury hears those words of, you know, locked ward or involuntary, you know, and they make assumptions in the back of their head. That word comes out, it resounds in their heads eventually whilst they're deliberating. Why would they say that? And that's unfair. There is no, it's not relevant to her state. She didn't discharge against medical advice, and she certainly went there of her own free accord. So I agree. The judge was a bit of a pussy there.
I didn't like that at all because the judge is snapping at. I mean, the judge is snapping at him in front of the jury.
Mm-hmm.
Yeah.
And I'm like, just get over it.
Again, makes it even worse because it looks like he's in the wrong. So that reinforces the bullshit that the prosecution have just said. So,
Dude, the judge shouldn't be fighting with the, you know, if he's got an issue, just be like, get up here. We're doing a sidebar.
Go ahead, counsel.
thank you.
I think we tend not to do against medical advice because if we are concerned about somebody's safety, we would not discharge them.
So you have another procedure available to you if you were concerned for somebody's safety.
Yes.
And that's this procedure you described about seeking an order for further commitment.
Correct.
Okay, thank you. Now, when a person comes and goes through that process and is placed on their unit and settled in, what is the plan after that? How often do they see providers?
They're assessed by a psychiatrist every single day that they're there. They have nurses who are checking in with them, mental health workers. They're offered group programming and medical monitoring, vital signs.
What types of group programming are offered to people while they're inpatient at McLean?
We offer skills groups, which are things like they're meant to teach patients skills so that they can tolerate distress. They can kind of observe their thoughts. It's meant to shore up their skills. Then there are some groups which are more just relaxed, I guess, such as going for fresh air walks or going to the recreation center, just, drawing or coloring. And yeah.
And are there other...
you can admit yourself and get assessed by someone like this, or you could go and colour in and draw pictures. Good job.
Things offered to patients once they're on a unit to assist them in their care, like counseling?
Yeah, those are the check-ins, and when they meet with the psychiatrist and the social worker, the counseling happens in those sessions as well, and also by the nurses and the mental health staff.
Okay. Now, does this procedure, or how it operates for any given patient, does it change if there's a holiday or a weekend?
I think they're still seen by a psychiatrist.
She's thinking if she knows, I have no objection. I'm going to object to the way she's answering.
All right. Why don't you rephrase the question?
I will, thank you. As far as your experience at McLean Hospital, does the schedule change when there's a weekend or a holiday?
The group schedule might change, but the staffing schedule doesn't change.
So the availability and the mental health worker that sees the patient, the social worker that checks in, and the psychiatrist and nurse, the team all stays the same even on weekend or holiday?
Other than the social worker.
Okay. And when I say stay the same, it could be different individuals, but It's somebody from that group, correct?
Yes.
Okay. So as far as your role as a psychiatrist, how do you get assigned patients when they are admitted to McLean inpatient?
It's random. There are beds that are open, and I carry a certain number of patients, and other psychiatrists have a certain number of patients, and whoever has an opening gets the admission.
Do you have to be there when the patient is admitted to have the patient assigned to you?
No.
And so do you rely on other psychiatrists to perform those tasks before you meet a patient?
Yes.
I'm going to draw your attention to particular...
Who's the witness here?
Well, and I want to ask you, how long has she been testifying?
Yeah.
I mean, if you removed the witness from this, it wouldn't change anything.
Well, I mean, it was like 30 minutes of background, and we're just now drawing the attention to Lindsay Clancy.
Yeah. I don't mind if somebody leads through background, but usually you lead through the background and it's really short. Most of this stuff is so fucking unnecessary. Also, Rob, everybody in chat is glad to see you. It's been a hot minute.
I know. I took some time. There's been a whole lot going on, and I'm starting to work my way back in.
Yep. For the folks in the chat, we're doing baby steps. Hopefully Rob will be back soon in full swing.
Yeah.
But
although you and I did have a whole week of vacation together. It was fun.
That was awesome. For the people who don't know, we made it out to a undisclosed location, and it was a good time. So, all right. So here we go, and now people have full proof of life.
Yeah, true.
Patient by the name of Lindsay Clancy that arrived at McLean in the early morning hours of January 1st of 2023. Do you recall that patient?
Yes.
Have you had the ability to review the records related to that patient prior to coming in today?
Yes.
And do you know where she came from?
The emergency department at MGH.
Okay. And did she come voluntarily, or did she come on some sort of section?
Again, for transportation, it's always a section, but then she signed in voluntarily, which is the section 10.
Okay. So your to your knowledge, she was brought in the early morning hours via ambulance.
Correct.
And did she go through that process of the clinical evaluation center in the early morning hours, approximately 4 a.m. on the 1st?
Yes.
And who saw her there?
I think the psychiatrist's name was Dr. Outlaw.
Okay, and you're familiar with Dr. Jasmine Outlaw?
I've never met her.
Okay, but she is a psychiatrist on staff.
Outlaw is a great name for a
Yep.
court case. It's like one of those situations where
Calling
like,
Dr. Outlaw.
I would like to apply to have the name of this witness excluded from the jury. I had a client once whose name was literally the crime he was accused of. And that would have been bad to take in front of a jury.
Yeah, I can see that would be problematic.
And
I don't know what on staff, what you mean by on staff.
well, she works at McLean.
Correct.
And so you were able to review the
That's a weird thing to not know what she means. But okay, I guess.
information she gathered in that first evaluation.
Yes.
And in reviewing that information, did you identify that the patient was identified as medically stable, right? Meaning she didn't have any acute medical issues that you had to worry about.
Correct.
And she was screened on the suicide screening.
Correct.
What was the chief complaint of the patient when she arrived at McLean?
She was unhappy. She was finding it hard to sleep if she didn't take medications.
Okay. And do you recall reviewing in the records that it was noted that she reported that she felt numb
Yes.
and that she was having some issues managing medication?
I don't know what you mean by that.
Or that she had some complaints about side effects or symptoms of medication?
Yes.
Now, when the psychiatrist and the clinical evaluation center gather the information, fair to say that it's primarily based on what's reported to the doctor by the patient.
Yes.
At McLean, do you have access to a patient's full psychiatric history or all of their records from other places?
It depends where the patient is coming from. I think that Dr. Outlaw did take an excerpt of the APS evaluation that was done at MGH, so I assume that she had access to that.
But I'm sorry, assumptions?
I mean,
I
she
can
would
ask
have
it a
had.
different
She
way.
doesn't know, she doesn't know.
As far as the full record of this particular patient that you were assigned to and responsible for, you reviewed all of the notes and information gathered by Dr. Outlaw on that first interaction with the patient, correct?
Yes.
And you indicated a little while ago in your testimony that McLean is affiliated with the Brigham
Correct.
Hospital and Mass General. So is it fair to say that those records from Mass General are available to you at McLean?
Yes.
And again, you indicated that that APS evaluation is something that's done at the emergency room, right?
Yes.
And is it common that that information come along with the patient?
This is fucking painful.
No, good. Just if you can answer that. You don't know?
I don't know.
Okay, all right, next question.
In this instance, when you reviewed the records, were you aware or did you see that there was some note to the APS evaluation from the Mass General ER?
I saw the excerpt of the APS evaluation in Dr. Outlaw's note.
Okay. And that excerpt from the APS evaluation was conducted by somebody by the name of Dr. Hogan, correct?
Correct.
And did you review a portion of the record indicating that the patient said to Dr. Hogan or reported thoughts of wishing to be dead but no plan,
Yes.
and that there was no violent or homicidal ideation, right?
Yes.
And that was observed at Mass General to have no evidence of psychosis, mania, obsessions, or current anxiety symptoms?
Correct.
So that's information that you knew before you met with the patient.
Yes.
And as far as what's reported when the patient comes to McLean, and in this instance, when Lindsay Clancy came, are you aware she reported during that clinical evaluation center evaluation that at the beginning of December, she had started Seroquel and Remeron and started to have intrusive and suicidal thoughts?
Yes.
That she attributed that to medication?
Yes.
Okay. And so what was the plan, the first plan that came out of that clinical evaluation center evaluation of Ms. Clancy?
She was continued on the medication she was admitted on. You know, the plan, they do the checks, they decide what medical monitoring you need, but she basically was admitted and
Okay.
the medications were the same.
And what was the security level, or how long were the checks assigned to her after this evaluation?
15 minutes.
And was she considered to be a high risk upon coming into the inpatient unit, or was she minimal risk?
Low. Minimal, yeah.
And were you aware of what's called the provisional diagnosis that was assigned to the?
So did you see that? She says low, and then she amends it.
Corrects it to what the ADA said. Yeah.
Yeah,
It's-
I'm like,
this is torture. It's absolute torture.
I would not be letting the ADA get away with this shit.
Shady as fuck, like I said.
Well, I don't know if it helps them at all, because here's the thing. Does anyone in the chat think that this doctor either A, wants to be testifying about any of this, or B, has any real knowledge about the day-to-day workings of the hospital beyond what her limited roles are?
Yeah. Nope. She knows fuck all. Nothing.
I don't know that she understands her own fucking role.
I don't know. The level of confusion that she has in giving these answers is ridiculous.
And this is their expert.
They're not hard questions.
No.
And usually you can't get a psychiatrist to shut up. Like, that's the challenge with them as witnesses. You ask them a question and they go off on a tangent for 25 minutes, and then you're trying to get them back in.
And I mean, I just found her to be so lacking in anything. The other thing that was striking to me is, the law and crime chat. The law and crime chat is almost universally, like, every trial, they're like, this person needs to be hanged from the yard arm, is basically the go-to feeling on everything.
Mm-hmm.
They did a poll today as to whether, like, the defense position should be followed, i.e. that she gets not guilty by reason of insanity, or the prosecution's theory. And it was 75-25 in favor of the defense.
Holy crap.
And the defense
Wow.
hasn't even started calling witnesses yet.
That's the part that's shocking to me.
Should never have gone
Like,
to trial.
Normally, when you like law and crime is like everybody needs to go to jail forever, and that's before they've even heard the first witness. And then normally, and the prosecution, if they're doing their job, should be at the point where everybody is like watching this going, these people are, these people are the worst. They're like, because the prosecution at this point is only calling their own, like, why?
This should be the pinnacle of your, like, you should right now have a factual foundation to be getting into the meat of your case. Like, you should be making your point by now.
At this point, the jury should be going, right, this person is the worst person ever. And then the defense should be sitting there trying to claw their way out of that hole. And instead, the defense is like sitting on top of the hill, kind of spitting at the prosecution.
I'm going to make a motion that we listen to like 5 more minutes of direct and then get to cross, because she is torturing
I'm
me.
jumping to the end because, yeah, she's awful. And we want to see the cross.
Her children, she was a caring mother, just like a caring mother. She
Oh, good. Get out that she's a caring mother. Excellent. Prosecution. Awesome.
had her parents around to help her. She had family and supports. We ensured that she would have outpatient psychiatric care for follow-up. She didn't have a history of suicide. She had no history of psychosis, postpartum psychosis. She had a stable place to live. So
The statement that she made to you that she wouldn't have completed the act of suicide because of her kids or her mom, was that something that you considered?
absolutely.
And the fact that during the time from admission on January 1st to the time she was discharged on January 5th, that she didn't make statements supporting suicidal ideation, was that a factor that you considered?
Yes.
And at no time during the time she was at McLean did she ever indicate that she had ever reported or had thoughts of harming anyone else, did she?
My God.
Had never stated that she had any thoughts of harming anybody else.
And ultimately, at the end of that conversation with her, or
You couldn't actually be, in mental distress if you don't tell everyone exactly what you're thinking.
The only thing the prosecutor hasn't said, well, and the thing is, she actually does too. She actually will say, "Isn't it true that?" If someone begins a question with, "Isn't it true that?" Pretty clear indication it's a leading fucking question. So,
Yeah. Yep.
the hour later, she was able to secure that appointment that you asked her to on her own.
Correct.
And so knowing that now the discharge has moved up a day, what was your plan for medication for her on discharge?
She would have continued on the Ativan to help her sleep at night. That was a short-term plan. Once she was feeling better or was able to sleep or her mood came back to baseline, she could taper off of it. She had trazodone to use as needed, and melatonin.
And as far as your recommendations for medication, it would be no more Seroquel. I guess, let me ask that question a different way.
Yes.
You didn't give her a new prescription for a different dosage of Seroquel, did you?
No.
And did you advise her to take Seroquel when she was home if she felt that she needed it?
I would assume she would take what I had prescribed.
Just to back up 1 second, as part of this treatment team plan for patients at McLean Hospital, is it fair to say that either you or other members of the team, either a mental health worker, a social worker, or a nurse, sometimes reach out to collaterals in order to try to gather information and assess a patient?
Yes.
And in this instance, are you aware that somebody reached out to Patrick Clancy to speak with him about his wife and her care?
Yes.
And were you aware that he reported that she hadn't ever had suicidal thoughts?
Yes.
And that he actually reported to the social worker that she was concerned about dependency.
Yes.
But she had told you that her husband was concerned. Is that correct?
Yes.
Oh, for fuck's sakes.
I know, it kills my lawyer brain.
And I mean, so I've been kind of having a guilty binge of various stuff, and what I've been having a guilty binge of is car salesman videos, specifically
That's
the car
odd.
salesman videos where the car salesmen are talking to other car salesmen.
All right, enough. Come on.
Their wife, right? Like, but the point of all of this is that spouses in a relationship kind of use each other as cover when they have objections. And also sometimes both spouses can think something and they'll sort of poke it to the other one because it's easier to do than that. So like all of this is just like, so isn't it true you were married?
Mm-hmm.
And I'm like, depends.
That's what I mean. Like, such a prior physician.
So, dude.
Sounds very Canada.
And I'm like, hey,
This is bad.
fuck. Get into like how you bonked her best friend than I ever do. So, you makes your choices. I never don't red line in the chat when he shared her.
Told the social worker.
And you're aware that he had made statements that he was unhappy with the medical care she was receiving at McLean?
I'm not surprised.
He said, I don't think.
Were you aware that he said he was very unhappy with the medical care she received?
She received, yes. She didn't.
Were you aware that is such bullshit? The correct objection to that one is objection relevance. What does it matter if she knows this?
Yeah.
Because the whole point of the question is just to testify with a thin question on it, right? So I hate that question. And you see him start to object and then start to, yeah.
specify. He didn't specify McLean.
Okay, thank you. And as far as you're aware, the patient themselves, Ms. Clancy, she never complained that she wasn't getting seen by staff or doctors, was she?
She never complained of that.
Did she ever file any sort of complaint with the hospital?
No.
And is there a mechanism for a person to file a complaint if they feel like they're not being treated?
Absolutely.
And is that information posted all over the units?
It is posted on the unit and the forms are available.
And a person, even if they're not on a one-to-one or directly interacting with a mental health worker or social worker, do they always have the ability to request to speak to somebody?
Absolutely.
And so even when maybe somebody from their team is not there or working, is there somebody always on call, a mental health worker, a social worker, a psychiatrist, a nurse, for a person to speak to if they felt they needed to?
Yes.
And in addition to...
she couldn't possibly have sucked, or else they would have complained on the numbers.
I know. It's so fucking stupid. This is so stupid. All of this is stupid. So can I just like speed run kind of the generality of what her testimony is supposed to be? Well, what these places usually are. So this is basically a state funded or a county funded facility, I imagine, because it sounds very similar to what we have here. Someone goes, they're admitted because they pose an imminent risk of harm to themselves or others, either self-reported or they're reported by somebody else. They're held over and evaluated on a daily or multi-daily basis. The evaluation are conducted by a psychotherapist or a psychiatrist rather, who sees probably 60 to 70 patients a day and doesn't have any real meaningful relationship with the individual they're evaluating other than to do the check the boxes on the form. And the form is as dumb as you imagine it. Have you expressed any, have you had experienced any suicidal ideations? Have you expressed, or do you have a plan of committing suicide? Do you have a plan of harming anyone? It's that dumb. And if the individual denies those things, then the evaluator kind of checks the box and goes on. The social worker who's there is either A, way too motivated, or B, way too underpaid and dealing with too much red tape to actually give a shit. So you have that's the swing. That's the option you get. You get someone who's either way too motivated and wants to hold you over even though they might not have the grounds, or someone who really doesn't give a shit and is only there to collect the paycheck.
And often their inquiries are specifically arranged around liability. So it's, do you have any suicidal ideation? The person's like, no. And they're like, cool. I don't want to make any further inquiries, because if I make any further inquiries, then we reopen liability. But I asked them if there was, any sort of risk of self-harm. They said no. I believe them. Therefore, if they do self-harm, we're not going to get sued. And I mean, a lot of that shit comes down to that's not where, we're just not going to get sued. And I see people saying it's a very expensive private facility. It doesn't necessarily change that.
It doesn't change the system that's designed. There's at least 2 hospitals that I'm thinking of that are privately funded that get patients of this setting that I've dealt with on multiple occasions. And the quality of assessment that you get is 100% dependent on who the individual is, whether they're complying or not complying, and then who the specific doctor is that's doing the assessment. Because you can get a shit assessment that doesn't catch anything, or you can get one that's actually comprehensive. And what I'm gleaning out of this was that Lindsay Clancy got a mere glance, like a couple of glances here and there, but she said the right words, or she didn't say necessarily the wrong words, because that's what gets you in trouble. You say the wrong things and they're like, oh shit, we're going to hold you. But she said just enough where they were like, you're not really a serious issue. Did you notice when the doctor was saying she had a stable home to go to? That gives you an indication of the people that they're oftentimes treating.
Yeah, and I mean, the whole... I'm very cynical about this because I see it in the drug treatment sphere. There's very good drug treatment, programs. But the most expensive drug treatment program that I know of is also really shit. And, and a lot of people in psych hospitals know very well the things that they can say that will get them moved from a voluntary to an involuntary stay.
Or vice versa.
Not to say those things.
Yep, and that's the thing. And people who are in the chat saying that I disagree. No. Here's the thing. I think some inpatient psychiatric and inpatient mental health treatment is critical. It has to be done right, and we have never. You have to be able to weed out the good from the bad, and you got to be able to pay the people who are good to keep them there, and you got to be able to fire the people who are bad to get them out of there, because it's too dangerous to get wrong. And we have these hospitals where you have good ones that aren't being elevated, you have bad ones that aren't being fired, and you have patients that are going in there and they're getting a prescription and getting released on the statement that, well, we trust the patient to comply with the prescription that I gave them. Really? How's that working?
Yeah, really, because they don't and they won't, and you know this. I don't know. I am somewhat cynical as to, like, some people get excellent quality care. Some people get really poor quality care, and you don't necessarily know which it's going to be. So, yeah. Here, it doesn't look like they made much effort to actually inquire as to what was going on. And, yeah.
You're meeting with her on January 4th, and after coming up with that plan for discharge on the 5th, are you aware that she then continued to engage in groups on the 5th, and that she continued to engage with mental health workers and social workers?
Yes.
And do you recall when she was discharged on the 5th? Was it in the morning or in the evening?
Afternoon, probably around 3-ish is my recall.
Okay. And upon discharge, was she provided with information that she could use when she was home? Like resources?
Yes.
And do you recall that she had asked about resources to find a new doctor at some point? Yes. And that she ultimately reported to the social worker that she felt comfortable managing at home?
Yes.
I may have one moment.
Sure.
So upon discharge, what did you actually prescribe her?
A 14-day supply of Ativan and a 14-day supply of trazodone.
Okay. And
All right, let's jump.
when you
to the
were
end of
having
her
conversations with her,
We had discussed going on Psychology Today, where
I'm sorry?
she
Oh,
was
God,
aware
you're here.
of Psychology Today.
Website.
Yes, she was given the name of a case manager through her insurance, who she could call.
So it's like,
Yeah, you got to back up about 15 seconds.
yeah.
nothing further. Thank you.
Ms. Reddington.
Just like to start off just by asking, District Attorney asked you about resources that were provided to her. What were the resources?
We had discussed going on Psychology Today, where
I'm sorry?
she was aware of the website Psychology Today.
Website.
Yes, she was given the name of a case manager through her insurance, who she could contact for assistance in finding new providers.
So,
So the resources are, you can call your insurance and you can go to a popular psychology website.
Psychology Today. But it's Psychology Today. Ian, it's not Psychology Yesterday. It's Psychology Today. It is the current psychology. It's not the former psychology. And it's on the World Wide Webs, which means it's at least quasi-interactive. And you can click it on your computer machine. You know, if you're in crisis, when I'm in crisis, you know what I do? I go on the World Wide Web and I look for help.
I was just like, are you fucking kidding me?
Well, I love the tactic that Reddington uses. So one of my favorite things to do in cross, and one of the things I teach all of my associates, one of my favorite tactics is you begin with the point the prosecutor just ended with, because you think the prosecutor is going to end with their strongest point. So you attack it. It's recency. So the prosecutor ends her monologue kind of about a minute and a half prior to this, prosecutor's going through, well, you left her with resources. Reddington jumps up and says, you were just talking about resources. Let's talk about this. Attack it immediately. And,
this is why when you're ending on like a point that you think is your strong point, you need to end on a point that is not just strong, but also really difficult to attack, right? Like this is a strong point, but it's also bulletproof is where you want to be, right? So I mean, this kind of, I was like, wow, all right.
For Memphis, Shad come
Here.
For Psychology Today and talking about her insurance company and what they would allow for her to reach out for what, other providers? Is that what it was?
Can you restate that?
Sure, of course. You referenced her insurance company.
All right. I'm going to skip right to the end of this. I don't want to hear what these guys have to say about, because we watched this on the last stream. So let's skip to the Luma, darling, and get a hang on. The end across.
So went back to work and she was experiencing a lot of, and then someone puts in quotes, situational anxiety. Is that correct?
That's what it states.
All right. So as a result, is that coming from her, or that word situational anxiety? Was that her words because it's in quotes, or was that you guys put that in there?
I didn't write that note.
Okay. But you factored that in your investigation, right?
I read it.
Okay. And as a result of this, she's
like, I read it. She doesn't admit that she, she's like, yeah, I'm not going to admit that I actually considered it, but I read it. Okay, cool. That's all we're at.
subsequently saw a psychiatrist that prescribed her Zoloft, right?
Yes.
And that would be Dr. Tufts, right?
Yes.
And 1 week after prescribing that, it says after 1 week of taking it, that she developed insomnia, correct?
Yes.
Okay. So that's an indication of a reaction that the patient had to the medication that was prescribed to her, being the SSRIs, Zoloft, right?
It could be a side effect, yes.
Could be, okay. And the psychiatrist told her to stop taking Zoloft, right?
That's what it states.
And do you know from your investigation and your evaluation of Lindsay Clancy, when the doctor told her to stop taking Zoloft? It was like, I mean, you can guess, it was like a week later, a couple of days later.
It would be
Worried that I'm gonna, harm myself with whatever is available. That's not a plan, but it is the kind of statement that if she fixes a problem.
You were asked some questions about the DSM-5, and I actually have a big version of the most recent version, the DSM-5 TR, meaning text revision. You're familiar with this book?
Thank you for.
The DSM-5 TR, meaning text revision. She was asked if she knew what that meant, and she's like, I don't know. And
clarified it.
Then the prosecutor just told her what it is. Here's a good question, but risky. Have you ever had a patient who denied having a plan to do the thing, but who you later learned did the thing?
Clarifying that, yes.
And counsel asked you some questions about postpartum depression and postpartum psychosis and whether they appear here in the DSM-5.
Yes.
Recall that line of questioning? And fair to say they do appear. They're not their own category, correct?
Yes.
But they do appear in conversation of bipolar disorder, bipolar disorder 1, having...
What the fuck does that even matter? Like, really? All right. I think I've had enough of stupidity and ignorance and fuckwits and fuckwittery and whatever the fuck you want to call it. I've had enough of it all because it's all fucking smoke screens and bullshit. Anyhow, it was nice to see Rob again. He actually looks like he's lost some weight. He's looking very healthy. So good luck to him. And shout out to Runkle of the Bailey if you haven't already subscribed to him. He's an awesome law tuber, an attorney. So head on over Runkle of the Bailey. And yeah, if you need like a legal version or dissection of a case or any case to do with guns, he's your man. So head on over. Okay. Thanks for listening. Thanks for watching. Thanks for laughing with me. And let justice prevail, hey? Hasta la vista, bitches. When I find my outro. And go.
File by file, I follow the thread. Names in the margin, words never said. Footsteps in silent states on the page. Power in the shadows, locked in a cage. If it's buried deep, we dig. If it's dressed up clean, we strip it. If the record bends, we read it straight. No easy answers, no closed case, no stone unturned. We want the truth, no stone unturned. Bring the proof.